In the Idaho 4 Brian Kober case, 2 years and 4 months later, we finally have, yes, portions of the 911 call, texts between Bethany Funke and Dylan Mortensen, and some other surprises.
Are these revelations that change everything we knew about this case? I'm Lainey Law.
And I'm attorney Andrew Myers.
And it sounds like we've got some big news to cover today.
Well, yeah, a whole ton of motions. In fact, in preparation for this podcast, I've been busy all week. So I open up the docket, and first of all, they've rearranged it. Second of all, there's about 24 new filings. Now, the filings were done a while back, but they were just made public on the court register now. And one of the more surprising things was there is a motion to allow in the texts between Bethany Funke and Dylan Mortensen. I don't know. Do you remember when people first said that the two of them were texting during the commission of the awful crime back on November 13th of 2022? Mm-hmm. Some people even denied that they happened. But you know what? So the texts really did happen between Bethany Funke and Dylan Mortensen, and they are in a court document. Here is a state's motion in limine regarding text messages and testimony. So in case you had any question as to whether these texts actually happen, now this is a motion to allow the texts in, even though they're hearsay. So they're making a legal argument to make sure that, or to argue that they be allowed, rather than waste time at trial. They're presenting this as a motion in limine. In advance of the trial comes now the state of Idaho, by and through the Latah County prosecuting attorney, and respectfully moves the court for an order in limine, allowing the state to admit the text messages of Dylan Mortensen and Bethany Funke regarding their conversations with each other on November 13th, 2022. The phone records were discovered in the hard drive provided on April 5th. Now, isn't that funny that it took from November 13th of 2022 until April 5th?
Almost 2 years.
Yeah. Well, no, it's November, December, January, February, March, April.
We're 5 March. Months.
Yeah. Took them some time. So they did get these. They did extract them. And what the state is saying is, well, all right, we admit that they're hearsay, but they should be allowed nonetheless through two exceptions to the hearsay rule, or if you're looking at the federal rule, which apparently Idaho follows, non-hearsay. They're either present sense impression, which is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it, or they're an excited utterance, which is a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. And rather than going through all the legal arguments that they're required to make, in the case at bar, starting on November 13th, 2022 at 2:10:29, Dylan Mortensen, DM, sends a text message to EG, the Uber driver, to inquire if he is driving. The state submits this text message exchange is not hearsay because it will not be offered for the truth of the matter asserted. That, by the way, is the definition of hearsay. Instead, it would be offered to show a timeline for the night. For example, Dylan Mortensen was awake and texting at 2:10:29. From 4:19:07 to 4:21:50, Dylan Mortensen attempts to call Bethany Funke, Xana Kernodle, Kaylee Goncalves, and Madison Mogen. All the calls were unanswered. The records of these calls are not hearsay, as they each do not meet the definition of a statement: oral assertion, written assertion, nonverbal conduct intended as an assertion. So here are, and we're seeing this for the first time now, the text messages between Dylan Mortensen and Bethany Funke. Dylan Mortensen to Bethany Funke: no one is answering. Second text: I'm really confused, RN. Dylan Mortensen to Kaylee Goncalves: Kaylee. Dylan Mortensen to Kaylee Goncalves: what's going on?
And then Bethany Funk to Dylan, yeah, dude, WTF. Xana was wearing all black.
Now, I wonder what's the relevance of that. All right, so Dylan Mortensen texts Bethany Funk, I'm freaking out. Dylan Mortensen to Bethany Funk. No, it's like ski mask almost.
STFU, actually.
So those are Bethany Funk to Dylan Mortensen. Then Dylan Mortensen says, or texts, I should say, like he had something over his forehead and a little mouth. Dylan Mortensen then to Bethany Funk, BF, I'm not kidding. I'm so freaked out.
So am I.
Bethany, Dylan Mortensen to Bethany Funk, my phone is going to die. F.
Come to my room, run. Run is crazy.
So now I got a little bit of a problem with this
Down.
bunch of texts here. And the reason I have a little bit of a problem is that we have to go back to the timeline. The question I have about these texts is they occurred after suspect vehicle 1, whoever was driving it, left. Here's the timeline according to the probable cause affidavit. 4 o'clock, after originally going to sleep, Dylan Mortensen is awoken by the sound she thought was Goncalves playing with the dog. 4:04, suspect vehicle 1 entering the area 4th time, can be seen on King Road, stopping and turning around in front of 500 Green Road, then driving back westbound. So, the car is just, circling around. 4:12, Kernodle likely awake and using the TikTok app. 4:17, neighboring security camera less than 50 feet away picked up distorted audio, what sounded like voices or a whimper. And then by 4:20, suspect vehicle 1 is next seen departing the area of the King Road residence. So according to the probable cause affidavit, these crimes all occurred between 4 o'clock and 4:17. Well, now, wait a minute. Let's go back to the texts. The texts are between 4:22 and 4:24. So these happened after the whole thing had happened. So, I guess what that means is, they're both aware of some kind of a ruckus in the house. They both know there's a ruckus in the house. They both, and you know what this says to me? This says to me that, that whole, I was going to use a different word, that whole business about the frozen shock phase is just, it was just made up because, these two girls are texting. They're very much aware.
Within 2 minutes, those text messages.
Yeah. And, so they're texting back and forth all of these things about, Xana wearing black and hearing the noise. What's going on? WTF. They're both very much awake and aware. All the above declarations are present sense impressions and excited utterances. This is supported by Dylan Mortensen's grand jury testimony, where she indicates she just witnessed a startling event, i.e., heard noises in residence and saw an unknown male in the residence. The declarations indicate both Bethany Funk and Dylan Mortensen are trying to make sense of the startling event contemporaneously or immediately following the startling event, i.e., no time for reflection or fabrication. Now, what the state is doing here is they're trying to say, yeah, we know that this is hearsay and it should be inadmissible. However, under the rule, it is non-hearsay or an exception to the hearsay rule, however you want to couch it, under whichever rules of evidence you're talking about, as an excited utterance. An excited utterance is something that goes around the hearsay rule because it comes so close in time, almost contemporaneous, that the speaker who was saying it didn't have any time to reflect. That's what an excited utterance. So in order to make the argument to get these texts in evidence, they have to say that it was exciting and it was shocking. But now they're contradicting themselves when they said that Dylan Mortensen was in a frozen shock phase. So I don't know which way they want to go. I don't know which argument they want to go, but it's clear that both Bethany and Dylan were wide awake and startled and shocked, and they knew something crazy was going on in their house. And you know what this does? This totally defeats the argument that there was anything that made sense about the 8-hour delay. What happened in that 8-hour delay between what happened in that house at 1122 King Road and then what happened, in those 8 hours? At 4:27:47, Dylan Mortensen calls Goncalves, call unanswered. 4:28:44, Dylan Mortensen calls Kernodle, call unanswered. 4:32:57, Dylan Mortensen sends a text message to Goncalves stating, please answer. This statement is a present sense impression. Here are the legal arguments to make sure this goes in. The next morning, Dylan Mortensen sends the following text messages starting at 10:23:23. Dylan Mortensen to Goncalves, please answer. Dylan Mortensen to Mogen, are you up? Dylan Mortensen to Goncalves, are you up? So again, these are not hearsay, the state argues, because they will not be introduced for the truth of the matter asserted, even if deemed hearsay. They are allowable as present sense impressions as they reflect a consistency and continuation of Dylan Mortensen's text messages. So these are at 10:23 in the morning. And again, the 911 call didn't come for another approximately hour and a half, from 10:23 to 11:58. So if you're in a frozen shock phase, whatever that is, are you texting 3 different people at 10:23 in the morning?
Well, and they also, she knew something was up in the sense that they were freaking out at 4 in the morning. She's up at 10, so presumably she didn't really sleep at all. I mean, maybe she did. Maybe she was able to get out 6 hours of sleep or less than 6 hours of sleep. But whether or not what happened in that time to wake up and be so concerned when they were already concerned at night is weird.
But there's more. At 11:39:09, Dylan Mortensen has a text exchange with her father. So she's not calling 911. She's calling her dad. These statements are not hearsay as they will not be introduced for the truth of the matter asserted, but intend to show a timeline for the morning. At 11:55, Dylan receives a text message from Jay stating, bro, this text message will not be introduced for the truth of the matter asserted. At 11:58, Dylan Mortensen calls EA, and we'll get into all that in the next document. This phone record is not a statement pursuant to the rule. Then at 11:51, Dylan receives a text message from Jay at 11:51:01 and a vandal alert at 1:04. So they kind of skipped over from 11:51 to 1:04 in this motion. They kind of skipped over the 911 call. You ask, why did they do that? Well, let's go to the 911 call. Here we go. Aren't you glad you asked?
No, aren't I glad I asked? All these text messages are making my skin crawl.
Yeah, there's 4 young people that have lost their lives in a violent crime overnight. And, we're calling dad. I don't know. I don't care that she's 20 years old. Since we've been discussing all of these, I've, noted a number of newspaper articles and news clips about 6-year-olds, 7-year-olds. In one case, a 12-year-old saw something horrible happening to her mother, and she called 911. So why it is that a 20-year-old needs to call the father, I know we're going to get comments. Don't judge. Okay. All right.
Yeah.
I won't. So this is the redacted state's motion in limine regarding the 911 call. It's similar. They're making the same argument. We know that it's hearsay, but we want it to come in under these 2 exceptions. So we're not going to even go through all of this because it's all good argument. If you're an attorney, let us know and we'll make sure you have access to this document and you can read a great. This would actually be a good case for a law school student who is looking for the difference between hearsay, present sense impression, and excited utterance. It's actually kind of interesting on all of that. So here is the 911 call.
911, location of your emergency.
Hi, something's happening. Something happened in our house. We don't know what. We have
What is the address of the emergency?
1122. No, don't.
What's the rest of the address?
Oh, Kings Road.
Okay, and is that a house or an apartment?
It's a house.
Can you repeat the address to make sure that I have it right?
I'll talk to you guys. We're and these are different voices, by the way. We live at the right, so we're next to them.
I need someone to repeat the address for verification.
The address, 1122 King Road.
And what's the phone number you're calling from?
What's your phone number? And remember that 4 different people were on Bethany Funk's phone. It was Bethany Funk's phone, but 4 people were on it. They redact the phone number. We don't know what else they're redacting here.
Okay, and tell me exactly what's going on.
One of the roommates who's passed out, and she was drunk last night, and she's not waking up. Now, no, we saw.
Okay.
Oh, and they saw some man in their house last night. Yeah. Hi. So the phone's obviously being passed around between these 4 people.
And are you with the patient? Okay, I need someone to keep the phone. Stop passing it around.
Can I just tell you what happened pretty much?
What is going on currently? Is someone passed out right now?
I don't really know, but pretty much at 4 a.m.
Okay, I need to know what's going on right now. If someone is passed out, can you find that out?
Yeah, I'll come. Come on, we got to go check, but we have to. Is she passed out? She's passed out. What's wrong?
Dispatch Moscow Lao ambulance for
She's not waking up.
unconsciousness 1122 King Road. 70 and is en route. Okay, one moment. I'm getting help started that way.
Okay, maybe.
Unintelligible 1122 King Road. All ambulance respond for unconsciousness 1122 King Road. I copy. 58 multiple RPs on the phone advising the roommate is on scene, is passed out and not waking up, believes she got drunk last night, and something about a male being in the room with them, being around. That one I copy about a 20-year-old female unconscious trying to get further. Copy.
Yeah, it's Evan. Okay.
Okay, and how old is she?
She's 20.
20, you said?
Yes, 20. Here. Do you want to talk to him?
Okay.
Hello.
I need someone to stop passing the phone around because I've talked to 4 different people.
Okay, sorry. They just gave me the phone.
Is she breathing?
Hello?
Is she breathing?
No.
Okay.
And now this is Bethany or Dylan. We don't know which one. I need you to talking to them. Okay, I can't talk to them. I need you to talk to them. Okay. Hello?
Okay, I've already sent the ambulance and law enforcement. Stay on the line.
Okay.
If there's a defibrillator available, send someone to get it now and tell me when you have it. Units responding, RPs advising.
Unintelligible.
The patient is not conscious, not breathing.
Unintelligible.
Okay, if there's a defibrillator available, send someone to get it now and tell me when you have it.
We don't have one.
Unconscious, not breathing.
Do you have a defibrillator?
Yep.
Yes, we have one.
But are you talking to the officer?
Yes.
Okay, I'm gonna let you go since he's there with you and can help you.
Okay, thank you. Bye.
Okay. Moscow 46 out. Copy. I think we have a homicide. Moscow engine 20 en route 1370 70 107. I relayed it.
Okay, so that's the transcript, and I should have mentioned this at the beginning. I meant to when we went from the texts early in the morning to the 911 call. The phone kept getting passed around. It was Bethany and Dylan, but also Hunter Johnson, who was a friend, and the neighbor Emily Allant were also there. Hunter Johnson and Emily Allant were apparently 2 of the, we don't know how many. I've read, yes, I know, we'll get comments. I've read that there were at least 4. I've also read that there were 6 other people, but Hunter Johnson and Emily Allant were 2, and apparently their boyfriend and girlfriend, they were 2 of the people that were on the line with the 911 call. So, again, bear in mind that this 911 call was at 11:58, not quite, almost 8 hours after whatever happened that night. And it just, I think, if anything, it deepens the mystery, don't you?
Oh my God. Well, and that's a good point too, especially we didn't review it, but like one of the messages that was sent was saying something like I'm screwed, like were they scared? Like they knew like it changes a lot of our perception of what happened because from up until this point, what we knew is that maybe she was drunk, she wasn't conscious enough to know what was happening. She thought she saw someone holding a vacuum cleaner. We even talked about here is like, what does that even mean? Because vacuum cleaners have a million different shapes. Did it look like a duffel bag? What did it look like? And like all these different things. And we were under the impression that Dylan, was not a reliable source, wasn't really understanding what was happening. But all these messages that we've seen here are kind of indicative that they knew that something was happening for 6 hours before they even started doing anything about it. They were concerned, waited, and however, whatever happened in those 6 hours, it wasn't until then where they tried again, which it does indicate that they did not know what happened to them, but it's still very strange.
Yeah, it deepens the mystery. A couple of different points come to mind. I do not think that it answers the question what happened in those 8 hours. What were these other people, including Hunter Johnson and Emily Alant? What were they all doing there? Why were they and Dylan Mortensen's father called? How could Dylan Mortensen have been in a frozen shock phase if she's making all these phone calls, she's making all these texts, she's talking to people? Obviously, some other people were called and came over to that home and did something. One of the issues that raises to me as an attorney is, where is the chain of custody to any of the evidence that law enforcement then at that time found in the house, if 911 was only called 8 hours later, when people were clearly conscious, texting, calling, having other people come over to the house. So there's a real, and then Brett Payne, who was the officer in charge of the whole thing, he didn't get there until apparently about 4 in the afternoon, 12 hours after the crime. So in my mind, it raises more questions than it answers. A lot of people, me included, have said, why did we never get the 911 call? Well, now we have it, and it doesn't really answer any questions. But if you want something even more inconclusive, look at this. Motion in limine regarding inconclusive data. Before we get to the substance of this motion, notice something here. The 3 defense attorneys listed at the top of this motion are now Ann Taylor, Elissa Masath, Bicca Barlow has been brought in pro hoc vice, and even though Jay Logston is down at the bottom, apparently he is out. He's the one that when the judge asked, well, what this international argument, that's falling on deaf ears. And Mr. Logston says, with a deer in the headlights look, it's an argument and it has to be made. Well, he's out. Anyhow, what is this inconclusive data and what is it all about? In grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, a swab of the left fingernail clippings from Madison Mogen. The data consisted of 3-person mixture. The swab from under Madison Mogen's fingernail included a 3-person mixture of DNA. The statistic, the likelihood ratio, was calculated assuming that Madison Mogen was a contributor to her own fingernails, and Miller testified that MM as followed, redacted. So this is frustrating in all of our cases today, isn't it?
But I'm also curious as to who was the body that they found unconscious, because they weren't damaged enough for them to know that they were dead immediately. They thought they were just like drunk. And now we have multiple people's DNAs under the fingernails, which I think further goes to say why, DNA evidence isn't conclusive, because now all these other people are being introduced. But this leads so many more questions, and we got answers from all of this.
Yeah, so I'm just wondering, because Dylan Mortensen was on the 2nd floor. She shared that floor with Ethan Chapin and Xana Kernodle. So did they not go beyond that up to the third floor where Madison Mogen and Kaylee Goncalves were? I mean, good point. So it makes me wonder if they just saw Ethan or Xana or both, and that freaked them out enough to do whatever they did, call their friends, call Hunter, call dad, or were they so freaked out they left, or did they not even go upstairs? But here, expanding beyond the language of the report would prejudice Mr. Koberger in that it might allow the jury to infer that the inconclusive data would mean that he might be included. So again, remember that this is it's the defense's motion. And so they're saying they want to keep this out. There were 3 people's DNA under her fingernails. And because it's inconclusive, it could mean that he's included. They go on to say the LR is a comparison of hypotheses. It is not a statement of identity or probability of identity. It simply asks the question, given the data, which hypotheses tested more likely for item Q13, that being the swab under Madison Mogen's fingernails, both hypotheses tested for each individual assumed that Madison Mogen's DNA was present. So when the lab generated an LR laid out above, the hypotheses tested were Madison Mogen, Kaylee Goncalves, and one unknown unrelated person versus Madison Mogen and 2 unrelated persons. So this comparison was done for all of the individuals listed in report number 7 and for Mr. Koberger in report 26 at the ISP, Idaho State Police Lab. Any number greater than 100 is considered a conclusive result indicating inclusion. So it goes on, and it is inconclusive until we get to page 4. Get out the dent. More importantly, Mr. Koberger has disclosed that through further independent laboratory testing, he is eliminated as a contributor to item 13.1. When Mr.
Dun, dun, dun.
Yeah, but he's not. He's not in the DNA samples underneath Madison Mogen's fingernails. When Mr. Koberger sought to overturn the grand jury indictment, he argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to the grand jury as exculpatory in an effort to elicit favorable evidence from Mr. Koberger. The independent lab testing conducted by the defense related to item 13.1 is indeed exculpatory. Mr. Koberger is excluded, and the state should be precluded from misleading the jury in any way. Conclusion: a fair trial is mandated by Mr. Koberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. The U.S. Constitution Amendments 5, 6, and 9, and then the Idaho Constitution articles. Expert testimony improperly elicited must be excluded. So kind of an interesting motion. The headline was that the DNA of 3 different people was found under Madison Mogen's fingernail. That was the headline. So
This changes everybody's interpretation of what happened.
Well, it could be a mystery third party. It could be Dylan, and could be anybody. Really, could be anybody. So then we get to the defense. Brian Koberger's attorneys don't want all the gruesome photographs let into evidence. That's what this boils down to. In other words, lots and lots of photographs were taken of the crime scene, and some of them certainly were extremely gruesome. I mean, just imagine from everything that we know about this case. I mean, who wants to look at it? But the state is going to want to bring in all those photographs. The case contains over 60. There's your terabytes.
Oh my God.
Now, this number has kind of been flexible. It's going up and down. But now we're looking at the case containing over 68 terabytes of data. That's like, how many file drawers of paper did we say that was? Enough to fill a skyscraper or something like that?
Well, and I like that the next line says this data contains thousands of photographs, many depict roughly the same content, and it kind of goes back to another case that we talk about regularly on this channel, Karen Reed, and how they had less than 100 photos total of the
Yeah.
scene. So
Makes no sense.
it's like obviously we appreciate being on this channel for you, but the discrepancies that we're seeing from state to state are jarring.
Yeah. Well, just imagine it's a 3-floor house with 6 bedrooms and a kitchen area, living room area, staircases. So we pick it up on the third sentence. There are photographs that depict the deceased as well as the same location without the deceased. Multiple officers took photographs of the same areas. Additionally, there are many hours of body-worn camera footage. Body-worn camera footage depicts the officers moving throughout the house. There are hundreds of photographs of autopsy proceedings. Now, I don't know about you, Lainey Law, if you've ever seen autopsy photographs, but they're not for someone with a weak stomach. They're not for someone with a weak stomach. I mean, an autopsy basically is pulling back layers, and somebody takes a photograph of them all so that the coroner can actually come to a conclusion. But so, in addition to this evidence, over 100 officers and investigators have been involved in the case, and hundreds of people that have been interviewed. Mr. Kohlberger seeks to protect the integrity of his trial and requests an order preventing inflammatory evidence, including testimonial evidence, be excluded. Appeals to emotion, passion, or prejudice of the jury through use of inflammatory tactics are impermissible. Mr. Kohlberger acknowledges the Idaho Supreme Court has held that a photograph cannot be excluded merely on the basis of being gruesome. However, Mr. Kohlberger is not making that motion. Rather, he is requesting that the state be prevented from introducing inflammatory evidence. We'll come back to that. What is inflammatory evidence? Multiple studies have found that mock jurors are more likely to convict when exposed to graphic photos. And there's a listing of a bunch of studies. I mean, that makes sense. If you see something that's that horrible, who wants to let somebody off the hook, whether they're guilty or not? As we saw from the juror in the Karen Reed case, the juror said, well, those who did feel that she was guilty on count 2 figured, she was there, the car was there, he was there. It must have been, So
it goes back to what I've been saying repeatedly, which is that in order to feel safe at night, these people have to believe that they have the right person and that there's not a random killer on the loose. So when you see all these gruesome photos, you don't want that to be you. It has to be this person that's guilty.
And then other studies have shown that judicial instructions to ignore such evidence are ineffective, while some have actually found such instructions cause jurors to place more emphasis on that evidence. So I've always felt that jury instructions are too complicated, too convoluted. They go on at length. And so even if there is a jury instruction to ignore the gruesome nature of the photographs, once you see somebody laying on the autopsy table with their guts spilling out, you can't get that out of your mind. There's no way. And so anyhow, they list all of these studies. Mr. Kohlberger's right to a fair trial, free from irrelevant, cumulative, and unfairly prejudicial evidence as guaranteed by the Constitution of the state of Idaho and the United States of America, would be violated to allow exhibits depicting gruesome details or the emotional reactions of the police officers at the scene or during their testimony at trial. The problem I have with this motion is there's nothing that's attached saying exhibit. Now, maybe there was something that was submitted to the court that was redacted and we can't see. I'll give them the benefit of the doubt. But there should be an attachment to this notice saying, we don't want this photo. This photo's okay. We don't want that photo because
what is general right now?
Very last sentence on page 2. Very last line, inflammatory evidence. What is inflammatory evidence? I mean, I know Oliver Wendell Holmes, or one of the Supreme Court justices with regard to pornography, said, I know it when I see it. It defies an absolute definition. And sure, inflammatory evidence, if you see something that's just terribly gruesome, as in the Massachusetts case of Nadworny, where they showed a body in somebody's trunk, that's inflammatory. a picture of a daisy out in a field is not inflammatory. But where's the line? Where's the definition? So someone, if this motion is to be taken seriously, and I think it will be, someone is going to have to sort through these 68 terabytes in advance and say, so my guess is that Judge Hippler on this particular motion might well say, guys, in advance of the trial, I want you to sit down and decide, and I've done that with the counsel on the other side of a case where there are a lot of photographs and drawings and plans and all the other stuff that we need to prove our case. We actually sat down at a conference table and went back and forth and agreed to some. No, we're not going to allow that. And we went into court with a list of agreed upon exhibits, and we narrowed it down to the ones we didn't agree on. So that's going to have to be done, because this motion is just a little bit, to my thinking, it's a little bit vague. Mm-hmm. The last one we're going to take a look at today is the state wants to kick out Brian Kohberger's alibi. And this is controversial because some people say, hey, he was out that night. He was driving around. He was nowhere near that. Our guy, Cy Ray, is going to be able to prove that he was nowhere near the house, that he went south. He didn't go east. He likes to gaze at the stars. Other people kind of said, yeah, right. And that's what this, without reading everything here, that is what the state is saying is like, yeah, right. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court in limine for an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi. And they go through it all, and they basically say that his alibi was not really. Former presiding judge John Judge's June 27, 2024 scheduling order, which is subsequent to the April 17, 2024 alibi disclosure deadline, and which makes no further reference to the alibi. It has now been approximately 20 months since the state first made its request for discovery disclosure alibi demand. The defendant has failed to comply with the prerequisites of the Idaho Code, and he has yet to specify, quote, the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi, as directed by the February 23rd, 2024 order setting deadlines and a hearing as discussed in the state's alibi, the state's April 26, 2024 response to the notice of defendant's supplemental response to the state's Idaho. So, in other words, the prosecution is saying, you haven't given us the specifics of where you were. You can't just say you were out. He likes to go out at night. He likes to look at the stars. He likes to go to the park. They're saying, no, you got to give us more specifics. And if you don't, for these reasons, the court should issue an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. So I don't know what you think about that one.
Well, my question about that one is, does it not are basically what they're saying is that if he were to if they put him on stand and they were going to ask him where were you that night, and he said he was out, wouldn't that can't he not lie in court about where he was if they were to ask him where he was directly, is my question.
Well, yeah, that's the point that the prosecution is trying to make. They're trying to say, look, you've got to be more specific so we have time to investigate that. You can't just surprise us in court and say, yeah, I was at the Wendy's on 25th Street and A Street, eating a Slurpee. I don't know what they have at Wendy's, but you can't spring that at trial. The statutes and the court rules in almost every state, and obviously in Idaho, say that, the defense, has a right to a fair trial, but part of that fair trial isn't springing stuff at the last minute. So there was one other motion I wanted to talk about briefly if we have time, and it was kind of hidden in all the hysteria about the 911 call and all the hysteria about the texts between Bethany and Dylan. The state brought one other motion. There are a lot of motions, but the one that I saw that was interesting was this sealed, then unsealed, redacted motion in limine for self-authentication of records in reliance on the rules. In other words, you can't just bring random stuff into court. It's got to be authenticated. Well, some things under the rules, federal and obviously in Idaho also, are self-authenticating. That sounds boring. Okay, let's go past all the verbiage. Here's a list of evidence that the prosecution wants to bring in. Albertson's video surveillance and business records. Remember that the day after November 13th of 2022, there is video of Mr. Koberger in Albertson's grocery store. Amazon financial and user records for Brian Koberger. What did he buy at Amazon? Corner Club video surveillance video for November 12th and 13th. That, of course, would be where Madison and Kaylee went the last night of their lives to have a few, and they talked to their friend Adam, the bartender. Look at this. Dick's Sporting Goods record of sale for Brian Koberger. Discover financial records for Kaylee Goncalves. Here's the DoorDash records for Xana. Elon financial records for Kaylee. Look at this. Floyd's Cannabis Company surveillance. Now, that has nothing to do with cannabis. That has nothing to do with weed, pot, whatever we want to call it. That is one of the businesses on the route that the prosecution claims that Mr. Koberger drove by. And so they claim that they have suspect vehicle number 1. Then we have Forrest Dax, Crypto.com financial records for Brian Koberger. What did he buy? We have the Grub Truck video surveillance that we've all seen, but they've got to get it into court. And the prosecution is saying, we want to get it in, and we're telling you that it is self-authenticating. Harbor Freight business and surveillance records, Idaho Central Credit Union. This is how attorneys are supposed to put a case together. Now, we talked in the Karen Reed case about how the prosecution kind of punted, and they had stuff here and there, and it was on flash drives on a desk with a sticky note, post-it note on it. And halfway through the trial, they decided they're going to bring in a this backwards inverted mirror image video. No, that's not done in a real court. No. And here the prosecution is saying, here's our stuff. Here's our list of self-authenticating video. Pennsylvania State Employees Credit Union, Rite Aid financial records, Sunset Mart, Target financial records, TikTok user records for Xana Kernodle.
I just want to point out, I appreciate how it's hard drive provided on this date, unlike some other cases that we've seen.
Yeah. So here the prosecution is saying, here's our list. They know that Judge Hippler is a no-nonsense kind of a guy. I think I can say that. And I don't think he would put up with, in the middle of trial. Oh, wait, we have Walmart's surveillance video here, Judge. I think this judge is going to say, take a hike. I don't know. So I thought, it goes on. One final page, Winco financial records for Brian Koberger, Winco financial records and video surveillance for Kaylee Goncalves, Madison Mogen, and or Xana Kernodle, hard drive for 4/5/23. And the last one would be the Washington State University parking records. So there's a lot, we could do a whole episode just going through all of that, what it is. We've highlighted some of it in previous episodes because it is interesting stuff. This is how a case is put together. I don't know if anybody watched our previous Read episode, but I pointed out that you have a trial plan, whether it's on a conference room table like we're sitting at here, or whether it's on a computer. Those of you who are more computer savvy than me might do it all on a computer. I know there's some great software out there on trial planning, but you plan it ahead and you tell the judge with a notice to the other side, here's a list. Here's a list of what you're going to, see. None of this bringing stuff in that's backwards or inverted or mirror image or whatever thesaurus, word you want to use. So I just thought that was interesting. Rightly so. Everybody's been focusing on the 911 call and the text messages and the DNA under Madison Mogen's fingernails. But as an attorney, I found the last two more interesting. So I don't know, Lainey. I always put you on the spot. I apologize in advance. But any final thoughts for us today?
I think our comment section is going to be a little wild on this one. I feel like our Koberger videos, I think a lot of people are more. So this is just my perception, and you guys can tell me if I'm wrong on this, but I feel like more people have been involved in the Karen Reed case because they were convinced that she's innocent versus the Koberger case. It seemed like people's minds are going more towards, oh, he's guilty, and they stopped caring. But with discoveries like these, I'm starting to wonder if how people are going to respond to this video. That being said, we do have some comments from you guys that we're going to try to get through super quick at the speed of light from one of our last Koberger videos, because I do want to say thank you guys. You've had some really good feedback. Carrie Berry's mom, 7855, says, at this time, presuming innocent because so far there's nothing I have seen that has proven guilt to me, which is good. And especially now with these new discoveries, we're going to have to see where this leads. And then we have this little interaction as our second comment. If you want to read this, Andrew.
Chopped Trials says, presumed innocent until proven guilty. Then Alexandra says, we all know it's guilty until proven innocent. A lot of people have felt that. And then Coleman says, that's in a court of law. In the court of public opinion, he's guilty AF. Now, last episode on Koberger that we did, we asked our commenters to tell us, whether you think he's guilty, whether you think he's innocent. I don't know about you, but when I went back through our comments, they were pretty much evenly split 50-50. So,
And on other channels, like, we try to be unbiased, but like other channels, like, you'd be surprised at their thoughts and opinions going on down there. Happy HK, which is one of our regulars, says not guilty, but it's concerning how the jury pool has been tainted by mainstream media who don't go through the documents the way you do. And people may have forgotten that the crime scene was demolished. The number one most alarming fact that shows the Great Wall of Defense teams facing. And
that's true. A lot of commenters have a lot of YouTubers, podcasters, and yes, everybody likes to say to us, and didn't you see this person? Didn't you see that person? One of them actually said, I implore you to watch so-and-so. We watch them all. This is our channel. We do it our way. Wasn't that Burger King that we do it our way? You can have it your way. We do it our way. We do watch it all. And the reason I got into that was because I was going to say, a lot of podcasters have very thoroughly gone into these issues, and a lot of them have done a good job. Some of them, but it's true though. The major media people have condensed everything that we just did into 90 seconds. That's what they have nice flashy videos because they have a graphics department that can take those texts and sparkle them up. But we didn't do that. But thank you for the compliment. Yeah, we do spend a lot more time because mainstream media has to fit the commercials in, and the news is done generally in about 12 minutes. Even in an hour-long show, the news is 12 minutes. The rest is weather, sports, fluff, features, and commercials. So thank you.
And then I'll let you take over this little bit of a longer comment.
Leon Cleardale. 1, abolish qualified and judicial immunity. 2, stricter and quicker punishment for lawyers and law enforcement who break the rules and the law. 3, public defender funds tied to prosecutor funds, state, county, city, at entry level. Every dollar the prosecution gets, public defenders get equal funding. Personally, I am not remotely convinced by the evidence so far against him, since all they have is touch DNA. Everything else they have brought up is just near the area and the same tower in a small college town. Thank you for the thought you put into that comment. A lot goes into that. We could discuss it for 30 minutes, but we have some time constraints. But thank you for putting all the thought into that comment. We do appreciate it.
And then for our last comment, we have Susan Davidson, 1691. Andrew, your tie is on point. You suit that color. As for BK thoughts, you guys have, yes, I agree. Scary times for all these folks facing juries just now. Have a lovely day from Scotland.
Thanks, Scotland. Thanks a lot. You can go into Macy's and ties. I was actually in Macy's around Christmas time looking at ties. $65 to $85 for a tie. And then the first time I wear it, I spill Chinese food.
Oh my gosh.
That's why I get mine at Amazon.com for a lot less.
Exactly. Yeah. With clothes, it's just like one little food incident gone wrong and you lose it all. But I do just want to say thank you guys for all the comments, and we really appreciate everything you guys have to say, and we look forward to hearing from you guys in the next episode.
Adios.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.